Hello, everybody. Tom Kerr here. I'm, as the title suggests, I'm going to be reading the opinion of the court. A lot of stuff here, a lot of papers. So it's going to take a little while. I hope you'll stick around and hear what this all has to say. So let's get going. Trump versus the United States. Docket number 23-939. The judicial summary. Let's see, where's that at? Nothing like being prepared, huh? Well, is that the case? Oh, darn it. Where did I put that piece of paper at? It's a good thing nobody's here. All right. This case involves former President Donald Trump, who was indicted on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleges that Trump conspired to overturn the election by spreading knowingly false claims of election fraud. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within his official responsibilities. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed this decision. The Supreme Court of the United States held that under the constitutional structure of separated powers, a former president is entitled to absolute immunity for criminal prosecution for actions within his conclusive and preclusive constitutional authority. He is also entitled to at least presumptive immunity from prosecution for all his official acts. However, there is no immunity for unofficial acts. The court vacated the judgment of the D.C. Circuit and remanded the case for further proceedings consistent with this opinion. The court emphasized that the president is not above the law, but under the system of separated powers, the president may not be prosecuted for exercising his core constitutional powers. So there you have it. So let's see, the syllabus. Where it is feasible, a syllabus, head note, will be released as being done in connection with this case at the time the opinion is issued. The syllabus constitutes no part of the opinion of the court, but is prepared by the reporter of decisions for the convenience of the reader. Syllabus. Trump v. United States, Sententori to the United States Court of Appeals for the District of Columbia Circuit. Number 23-939, argued April 25th, 2024, decided July 1, 2024. A federal grand jury indicted former President Donald Trump on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed. Both the district court and the D.C. Circuit declined to decide whether the indicted conduct involved official acts. Held. Under our constitutional structure of separated powers, the nature of a presidential power entitles a former president to absolute immunity from criminal prosecutions for actions within his conclusive and preclusive constitutional authority. and he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. Determining whether and under what circumstances such a prosecution may proceed requires careful assessment of the scope of presidential power under the Constitution. The nature of that power requires that the former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, his immunity must be absolute. As for his remaining official actions, he is entitled to at least presumptive immunity. Article 2 of the Constitution vests executive power in a president of the United States. The president has duties of unrivaled gravity and breadth. Trump v. Vance, 591 U.S. 786 through 800, his authority to act necessarily stems either from an act of Congress or from the Constitution itself. Youngstown Sheet and Tube Company versus Sawyer, 343 U.S. pages 579 through 585. In the latter case, the president's authority is sometimes conclusive and preclusive. When the president exercises such authority, Congress cannot act on and the courts cannot examine the president's actions. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not criminalize the president's actions within his exclusive constitutional power. Neither may the court adjudicate a criminal prosecution that examines such presidential actions. The court thus concludes that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. 2. Not all of the president's official acts fall within this conclusive and preclusive authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive constitutional authority do not extend to conduct in areas where his authority is shared with Congress. To determine the president's immunity in this context, the court looks primarily to the framers' design of the presidency within the separation of powers, precedent on presidential immunity in the civil context, and in criminal cases where a president resists prosecutorial demands for documents. The framers designed the presidency to provide for a vigorous and energetic executive. The Federalist number 70, page 471 through 472, Alexander Hamilton, they vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. Nixon v. Fitzgerald, 457 U.S. 731, 750, appreciating the unique risks that arise when the president energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, the court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. In Fitzgerald, for instance, the court concluded that a former president is entitled to absolute immunity from damages, liability for acts within the outer perimeter of his official responsibility. The court's dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision, Clinton v. Jones. By contrast, when prosecutors have sought evidence from the president, the court has consistently rejected presidential claims of absolute immunity. During the treason trial of former Vice President Aaron Burr, for instance, Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subject to a subpoena. Marshall simultaneously recognized, however, the existence of a privilege to withhold certain official papers, U.S. v. Burr. And when a subpoena issued to President Richard Nixon, the court rejected his claim of absolute privilege, U.S. v. Nixon, but recognized the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making. It held a presumptive privilege protects presidential communications. Because that privilege relates to the effective discharge of a president's powers, the court deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. See what's this all about? Had one person in here. Holy moly. They gave up on me. By contrast, when prosecutors have sought evidence from the president, the court has consistently rejected presidential claims of absolute immunity. During the treason trial, criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and function of the executive branch than simply seeking evidence in his possession. The danger is greater than what led the court to recognize absolute presidential immunity from civil damage liability. That the president would be chilled from taking the bold and unhesitating action required of an independent executive. Fitzgerald. Although the president might be exposed to fewer criminal prosecutions than civil damage suits, the threat of trial, judgment, and imprisonment is far greater deterrent than plainly more likely distort presidential decision making. Likely to distort presidential decision making than the potential payment of civil damages. The hesitation to execute duties of his office fearlessly and fairly might result when a president is making decisions under a pall of potential prosecutions, McDonnell v. United States. Unique risks to the effective functioning of government, but there is also compelling public interest in fair and effective law enforcement. Taking into account these competing considerations, the court concludes that the separation of powers principle explicated in the court's precedent necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibilities. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. At a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to the act would pose no dangers of intrusion on the authority and function of the executive branch. 3, as for a president's unofficial acts, there is no immunity. Although presidential immunity is required for official actions to ensure that the president's decision-making is not distorted by the threat of future litigation stemming from those actions, that concern does not support immunity for unofficial conduct. The separation of powers does not bar prosecution predicated on the president's unofficial acts. The first step in deciding whether a former president is entitled to immunity from a particular prosecution is to distinguish his official from unofficial actions. In this case, no court has thus far drawn that distinction in general or with respect to the conduct alleged in particular. It is therefore incumbent upon the court to be mindful that it is a court of final review and not first review. Critical threshold issues in this case are how to differentiate between a president's official and unofficial actions, and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. The court offers guidance on those issues. When the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action. but the breadth of the president's discretionary responsibility under the Constitution and laws of the United States frequently makes it difficult to determine which of his innumerable functions encompasses a particular action. The immunity the court has recognized, therefore, extends to the outer perimeter of the president's official responsibility, covering actions so long as they are not manifestly or palpably beyond his authority. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such a highly intrusive inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. With the above principles in mind, the court turns to the conduct alleged in the indictment. Certain allegations, such as those involving Trump's discussion with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Other allegations, such as those involving Trump's interaction with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. The indictment alleges that as part of their conspiracy to overturn the legitimate results of the 2020 presidential election, Trump and his co-conspirators attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slates of electors. According to the indictment, Trump met with the acting attorney general and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending letters from the department to those states regarding such fraud. The indictment further alleges that after the acting attorney general resisted Trump's request, Trump repeatedly threatened to replace him. The government does not dispute that the indictment's allegations regarding the Justice Department involves Trump's use of official power. The allegations, in fact, plainly implicate Trump's conclusive and preclusive authority. The executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime, Nixon 418, and the president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties. Fitzgerald 457 U.S. at 750. The indictment alleges that the requested investigations were shams or proposed for an improper purpose, do not divest the president of exclusive authority over the investigation or prosecutorial, or does not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials. Because the president cannot be prosecuted for conduct within his exclusive constitutional authority, Trump is absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. The indictment next alleges that Trump and his co-conspirators attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceedings to fraudulently alter the election results. In particular, the indictment alleges several conversations in which Trump pressured the vice president to reject states' legitimate electoral votes or send them back to the state legislatures for review. Whenever the president and vice president discuss their official responsibility, they engaged in official conduct. Presiding over the January 6th certification proceeding, at which members of Congress count the electoral votes, is a constitutional and statutory duty of the vice president. The indictments alleged that Trump attempted to pressure the vice president to take particular actions in connection with his role at the certification proceedings, thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. The question then becomes whether that presumption of immunity is rebutted under the circumstances. It is the government's burden to rebut the presumption of immunity. The court therefore remands the district court to assess in the first instance whether a prosecution involving Trump's alleged attempts to influence vice president's oversight of the certification proceedings would pose any dangers of intrusion on the authority and functions of the executive branch. The indictment's remaining allegations involve Trump's interactions with persons outside the executive branch, state officials, private parties, and the general public. In particular, the indictment alleges that Trump and his co-conspirators attempted to convince certain state officials that election fraud had tainted the popular vote count in their state, and thus the electoral votes for Trump's opponents needed to be changed to the electoral votes for Trump. After Trump failed to convince those officials to alter their state's processes, he and his co-conspirators allegedly developed and effectuated a plan to submit fraudulent slates of presidential electors to obstruct the certification proceedings. On Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity and proper administration of the federal election. As the government sees it, however, Trump can point to no plausible source of authority enabling the president to take such actions. Determining whose characterization may be correct and with respect to which conduct requires a fact-specific analysis of the indictment's extensive and interrelated allegations. The court accordingly remands to the district court to determine the first instance whether Trump's conduct in this area qualifies as official or unofficial. The indictment also contains various allegations regarding Trump's conduct in connection with the events of January 6th itself. The alleged conduct largely consists of Trump's communications in the form of tweets and a public address. The president possesses extraordinary powers to speak to his fellow citizens on their behalf. Trump v. Hawaii. Most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities. There may, however, be contexts in which the president speaks in an unofficial capacity, perhaps as a candidate for office or party leader. To the extent that may be the case, objective analysis of content, form, and context will necessarily inform the inquiry. Whether the communication alleged in the indictment involve official conduct may depend on the content and context of each. This necessarily fact-bound analysis is best performed initially by the district court. The court therefore remands to the district court to determine in the first instance whether this alleged conduct is official or unofficial. Presidents cannot be indicted based on Presidents cannot be indicted based on conduct for which they are immune from prosecution. On remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution. And the parties in the district court must ensure that sufficient allegations support the indictment's charges. Without such conduct, testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. Trump asserts a far broader immunity than the limited one the court recognizes, contending that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. But the text of the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached and convicted. Historical evidence likewise lends little support to Trump's position. The Federalist Papers on which Trump relies concerned the checks available against a sitting president. They did not endorse or even consider whether the impeachment judgment clause immunizes a former president from prosecution. Transforming the political process of impeachment into a necessary step in the enforcement of criminal law finds little support in the text of the Constitution or the structure of the nation's government. The government takes a similarly broad view, contending that the president enjoys no immunity from criminal prosecution for any action. On its view, as applied, challenges in the course of the trial suffice to protect Article 2 interests, and review of district court's decision on such challenges should be deferred until after trial. But questions about whether the president may be held liable for particular actions consistent with the separation of powers must be addressed at the outset of a proceeding. Even if the president were ultimately not found liable for certain official actions, the possibility of extended proceedings alone may render him unduly cautious in the discharge of his official duties. The Constitution does not tolerate such impediments to the effective functioning of government. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? In answering that question, unlike the political branches and the public at large, the court cannot afford to fixate exclusively or even primarily on present exigencies. Enduring separation of powers principle guides our decision in this case. The president enjoys no immunity for his unofficial acts, and not everything that a president does is official. The president is not above the law, but under our system of separated powers, the president may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive immunity from prosecution for his official acts. That immunity applies equally to all occupants of the Oval Office. Chief Justice Roberts delivered the opinion of the court in which Thomas, Alito, Gorsuch, and Kavanaugh joined in full, and in which Justice Barrett joined except as to Part 3. Justice Thomas followed a concurring opinion. Justice Barrett filed an opinion concurring in part. Sotomayor filed a dissenting opinion, which Kagan and Jackson joined. Jackson filed a dissenting opinion. And here comes the Roberts opinion of the court on writ of Centauri to the United States Court of Appeals for the District of Columbia Circuit, July 1, 2024. Chief Justice Roberts delivered the opinion of the court. This case concerns the federal indictment of a former president of the United States for conduct alleged to involve official acts during his tenure in office. We consider the scope of a president's immunity from criminal prosecution. Section 1. From January 7, 2017 until January 2021, Donald J. Trump served as President of the United States. On August 1, 2023, a federal grand jury indicted him on 4 counts for conduct that occurred during his presidency following the November 20th election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. According to the indictment, Trump advanced his goal through 5 primary means. First, he and his co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to change electoral votes for Trump's opponent, Joseph Robinette Biden Jr., to electoral votes for Trump. Second, Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states and caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceedings on January 6th. Where to go? Third, Trump and his co-conspirators attempted to use the Justice Department to conduct a sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. Fourth, Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6th certification proceedings to fraudulently alter the election results. And when that failed on the morning of January 6th, they repeated knowingly false claims of election fraud to gather supporters, falsely told them that the vice president had the authority to and might alter the election results, and directed them to the Capitol to obstruct the certification process. Fifth, when a large and angry crowd violently attacked the Capitol and halted the proceedings, Trump and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convene members of Congress to further delay the certification. Based on this alleged conduct, the indictment charged Trump with 1, conspiracy to defraud the United States in violation of 18 U.S. Code 371. 2, conspiracy to obstruct an official proceeding violation of 1512K. 3, obstruction of and attempting to obstruct an official proceeding in violation of 1512C2, 2, and 4, conspiracy against the rights in violation of 241.1. Based on this alleged conduct, the indictment charged Trump with 1, conspiracy to defraud the United States in violation of U.S. Code 18 U.S.C. 371. 2, conspiracy to obstruct an official proceeding in violation of 1512K. 3, obstruction of an attempt to obstruct an official proceeding in violation of 1512C2. And 4, conspiracy against rights in violation of 241.1. Trump moved to dismiss the indictment based on presidential immunity. In his view, the conduct alleged in the indictment, properly characterized, was that while he was president, he, 1, made public statements about the administration of the federal election. 2, communicated with senior Justice Department officials about investigating election fraud and about choosing the leadership of the department. 3, communicated with the state officials about the administration of the federal election and their exercise of official duties with respect to it. Communicated with the vice president and with members of Congress about the exercise of their. Regarding the election, authorized or directed others to organize contingent sets of electors in furtherance of his attempt to convince the vice president to exercise his official authority in a manner advocated by President Trump. Motion to dismiss indictment based on presidential immunity in number 123, blah, blah, blah. Trump argued of the indictments alleged fell within the core of his official duties. And he contended that a president had absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, to ensure that he can undertake the especially sensitive duties of his office with bold and unhesitating action. The district court denied the motion to dismiss, holding that former presidents do not possess absolute federal criminal immunity for any acts committed while in office. The district court recognized that the president is immune from damages, liability in civil cases to protect against chilling effects such exposure might have on carrying out his responsibility. But it reasoned that the possibility of vexatious post-presidency litigation is much reduced in the criminal context in light of the robust procedural safeguards attended to federal criminal prosecutions. The district court declined to decide whether the indicted conduct involved official acts. The D.C. Circuit affirmed per curiam, citing Marbury versus Madison. Court distinguished between two kinds of official acts, discretionary and ministerial. It observed that although discretionary acts are only politically examinable, the judiciary has the power to hear cases involving ministerial acts that an officer is directed to perform by the legislature. From this distinction, the D.C. Circuit concluded that the separation of powers doctrine as expounded in Marbury and its prodigy necessarily permits the judiciary to oversee the federal criminal prosecution of a president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's laws. In the court's view, the fact that Trump's actions allegedly violated generally applicable criminal laws meant that those actions were not properly within the scope of his lawful discretion. The D.C. Circuit thus concluded that Trump had no structural immunity from the charges in the indictment. Like the district court, the D.C. Circuit declined to analyze the actions described in the indictment to determine whether they involved official acts. We granted Centauri to consider the following question: whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under what circumstances such prosecution may proceed. Doing so requires careful assessment of the scope of presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of our republic. The parties, therefore, before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. They also agree that some of the conduct described in the indictment includes actions taken by Trump in an unofficial capacity. They disagree, however, about whether a former president can be prosecuted for his official actions. Trump contends that just as a president is absolutely immune from civil damages liability for acts within the outer perimeter of his official responsibilities, he must be absolutely immune from criminal prosecution for such acts. Brief for petitioner 10, and Trump argues that the bulk of the indictment's allegation involved conduct that was officially in his official capacity as president. One moment, please. Trump argues that the bulk of although the government agrees that some official actions are included in the indictment, president's allegations, it maintains that a former president does not enjoy immunity from criminal prosecution for any actions, regardless of how they are characterized. See brief for the United States 9. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the president's exercise of his core constitutional powers. This immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute, or instead whether the presumptive immunity is sufficient. Article 2 of the Constitution provides that the executive power shall be vested in the President of the United States of America. The President's duties are of unrivaled gravity and breadth. Trump v. Vance, 591 U.S. 786 to 800, 2020. They include, for instance, commanding the armed forces of the United States, granting reprieves and pardons for offenses against the United States, and appointing public ministers and consuls, the justices of this court, and officers of the United States. He also has important foreign relations responsibilities, making treaties, appointing ambassadors, recognizing foreign governments, meeting foreign leaders, overseeing international diplomacy and intelligence gathering, and managing matters related to terrorism, trade, and immigration. Domestically, he must take care that the laws are faithfully executed, and he bears responsibility for the actions of the many departments and agencies within the executive branch. He also plays a role in lawmaking by recommending to Congress the measures he thinks wise and signing or vetoing the bills that Congress passes. No matter the context, the president's authority to act necessarily stems either from an act of Congress or from the Constitution itself. In the latter case, the president's authority is sometimes conclusive and preclusive. When the president exercises such authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. The exclusive constitutional authority of the president disables the Congress from acting upon the subject, and the courts have no power to control the president's discretion when he acts pursuant to the powers vested exclusively to him by the Constitution, Marbury. If the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so. In Youngstown, for instance, we held that President Truman exceeded his constitutional authority when he seized most of the nation's steel mills. But once it is determined that the president acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. The Constitution, for example, vests the power to grant reprieves and pardons for offenses against the United States. And the president, during this and after the Civil War, President Lincoln offered full pardon with restoration of property rights to anyone who had engaged in the rebellion, but agreed to take an oath of allegiance to the Union. But in 1870, Congress enacted provisions that prohibited using the president's pardon as evidence of restoration of property rights. Chief Justice Chase held the provision unconstitutional because it impaired the effect of a pardon and thus infringed the constitutional power of the executive. To the executive alone is entrusted the power of pardon, and the legislature cannot change the effect of such a pardon any more than the executive can change a law. The president's authority to pardon, in other words, is conclusive and preclusive, disabling the Congress from acting upon the subject. Some of the president's other constitutional powers also fit that description. The president's power to remove and thus supervise those who wield executive power on his behalf, for instance, follows from the text of Article 2, Celia Law LLC versus Consumer Financial Protection Bureau. We have thus held that Congress lacks authority to control the president's unrestricted power of removal with respect to executive officers of the United States whom he has appointed. Myers versus United States. Youngstown, Justice Jackson concurring, citing the president's exclusive power of removal in executive agency as an example of conclusive and preclusive constitutional authority. Celia Law, U.S. 591, 215, noting only two exceptions to the president's unrestricted removal power. The power to control recognition determinations of foreign countries is likewise an exclusive power of the president. Congressional commands contrary to the president's recognition determinations are thus invalid. Congress cannot act on and courts cannot examine the president's actions on subjects within his conclusive and preclusive constitutional authority. It follows that an act of Congress, either a specific one targeted at the president or generally applicable one, may not criminalize the president's action within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examines the presidential actions. We thus conclude that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. But of course, not all of the president's official acts fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the president sometimes acts pursuant to an express or implied authorization from Congress, or in a zone of twilight where he and Congress may have concurrent authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive authority, therefore, do not extend to conduct in areas where his authority is shared with Congress. We recognize that only a limited number of our prior decisions guide determination of the president's immunity in this context. That is because proceedings directly involving a president have been uncommon in our nation, and decisions of the court in this area have accordingly been rare and episodic. To resolve the matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers, our precedent on presidential immunity in civil contexts, and our criminal cases where a president resisted prosecutorial demands for documents. The president occupies a unique position in the constitutional scheme. The only person who alone composes a branch of government. The framers sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single, constitutionally indispensable individual the ultimate authority that, in respect to other branches, the Constitution divides among many. They deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, and the protection of property, and the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of government. The framers accordingly vested the president with supervisory and policy responsibility of utmost discretion and sensitivity. He must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. There accordingly exists the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially with the duties of his office. Appreciating the unique risks to the effective functioning of government, that arise when the president's energies are diverted by proceedings that might render him unduly cautious in discharge of his official duties, we have recognized presidential immunities and privileges rooted in the constitutional traditions of the separation of powers and supported by our history. In Nixon v. Fitzgerald, for instance, we recognize that a functionally mandated incident of his unique office, a former president is entitled to absolute immunity from damage liabilities predicated on his official acts. That case involved a terminated Air Force employee who sued former President Richard Nixon for damages, alleging that Nixon approved an Air Force reorganization that wrongfully led to his firing. In holding that Nixon was immune from that suit, our dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. The singular importance of the president's duties implicating matters likely to arouse the most intense feeling, coupled with the sheer prominence of his office, heightens the prospect of private damage suits that would threaten such diversion. We therefore concluded that the president must be absolutely immune from damages liabilities for acts within the outer perimeter of his official responsibility. By contrast, when prosecutors have sought evidence from the president, we have consistently rejected presidential claims of absolute immunity. For instance, during the treason trial of former President Aaron Burr, Chief Justice Marshall rejected President Thomas Jefferson's claims that the president could not be subject to a subpoena. Marshall reasoned that the law does not discriminate between the president and a private citizen. U.S. v. Burr. Because the president does not stand exempt from general provisions of the Constitution, including the Sixth Amendment's guarantee that those accused shall have compulsory process for obtaining witnesses for their defense, a subpoena could issue. Marshall acknowledged, however, the existence of privilege to withhold certain official papers and ought not on light ground be forced to public view, stating that nothing before the court showed that the document in question contained any matter of the disclosure of which could endanger the public safety, and he noted that the court may not be required against the president as against an ordinary individual. Similarly, when a subpoena issued to President Nixon to produce certain tape recordings and documents relating to his conversations with aides and advisors, this court rejected his claim of absolute privilege, given the constitutional duty of the judicial branch to do justice in criminal prosecutions. United States v. Nixon. But we simultaneously recognize the public interest in candid, objective, and even blunt or harsh opinions of presidential decision-making, as well as the need to protect communications between high government officials and those who advise and assist them in the performance of their manifold duties. Because the president's need for complete candor and objectivity from advisors calls for great deference from the courts, we held that a presumptive privilege protecting presidential communications, that privilege, we explained, relates to the effective discharge of the president's powers. Thus, it deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and function of the executive branch than simply seeking evidence in his possession. As in Burr and Nixon, the danger is akin to, and indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability. That the president would be chilled from taking the bold and unhesitating action required of an independent executive. Although the president might be exposed to fewer criminal prosecutions than the range of civil damage suits that might be brought by various plaintiffs, the threat of trial, judgment, and imprisonment is far greater deterrent. Potential criminal liability and the peculiar public opprobrium that attaches to criminal proceedings are plainly more likely to distort presidential decision-making than the potential payment of civil damages. The hesitation to execute the duties of his office fearlessly and fairly might result when a president is making decisions under a pall of potential prosecutions, raises unique risks to the effective functioning of government. The president inclined to take one course of action based on public interest may instead opt for another, apprehensive that criminal penalties may befall him upon his departure from office. And if a former president's official acts are routinely subject to scrutiny in criminal prosecutions, the independence of the executive branch may be significantly undermined. The framers' design of the presidency did not envision such a counterproductive burdens on the vigor and energy of the executive. Federalist number 70. We must, however, recognize the countervailing interest at stake. Federal criminal law seeks to redress a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in fair and effective law enforcement. The president charged with enforcing federal laws is not above them. Chief Justice Marshall's decision in Burr and our decision in Nixon recognize the distinct interest present in criminal prosecution. Although Burr acknowledged that the president's official papers may be privileged and publicly unavailable, it did not grant him an absolute exemption from responding to subpoenas. Nixon likewise recognized a strong protection for the president's confidential communications, a presumptive privilege, but it did not entirely exempt him from providing evidence in criminal proceedings. Taking into account these competing considerations, we can conclude that the separation of powers principle explicated in our precedent necessitates at least a presumptive immunity from criminal prosecution for a president's acts within our outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without due caution. Indeed, if presumptive protections for the president is necessary to enable the effective discharge of his powers when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for official acts unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusions on the authority and function of the executive branch. But as we explained below, the current stage of the proceedings in this case does not require us to decide whether this immunity is presumptive or absolute. Because we need not decide that question today, we do not decide it. One case in more than 2 centuries does not afford enough experience to definitively and comprehensively determine the president's scope of immunity from criminal prosecution. As for the president's acts, there is no immunity. The principle we set out in Clinton v. Jones confirmed as much. When Paula Jones brought a civil lawsuit, we rejected his argument that he enjoyed temporary immunity from the lawsuit while serving as president. Although the presidential immunity is required for official actions to ensure the president's decision-making is not distorted by the threat of future litigation stemming from those actions, the concern does not support immunity for unofficial conduct. The justifying purposes of the immunity we recognize in Fitzgerald and the one we recognize today are not that the president must be immune because he is the president. Rather, they are to ensure that the president can undertake his constitutionally designated functions effectively, free from undue pressure and distortions. It is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis. Foster v. White. Separations of power does not bar prosecution predicated on the president's unofficial acts. Section 3. Determining whether a former president is entitled to immunity from a particular prosecution requires applying the principles we have laid out to this conducted issue. The first step is to distinguish his official from unofficial actions. In this case, however, no court has thus far considered how to draw that distinction in general or with respect to the conduct alleged in particular. Despite the unprecedented nature of this case and the very significant constitutional questions that it raises, the lower courts rendered their decision on highly expedited basis. Because those courts categorically rejected any form of presidential immunity, they did not analyze the conduct alleged in the indictment to decide which of it could be categorized as official and which was unofficial. Neither party has briefed that issue before us, though they discussed it in oral arguments in response to questions. And like the underlying immunity question, that categorization raises multiple unprecedented and momentous questions about the powers of the president and the limits to his authority under the Constitution. As we have noted, there is little pertinent precedent on those subjects to guide our review of this case, a case that we too are deciding on an expedited basis. Less than 5 months after we granted the government's request to construe Trump's emergency application for a stay as a petition for Centauri, grant that petition and answer the consequential immunity question. Given all these circumstances, it is particularly incumbent upon us to be mindful of our frequent admonition that ours is a court of final review, not first review. Critical threshold issues in this case are how to differentiate between president's official and unofficial actions, and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. We offer guidance on those issues below. Certain allegations, such as those invoking Trump's discussion with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Although we identify several considerations pertinent to classifying those allegations, in determining whether they are subject to immunity, that analysis ultimately is best left to the lower courts to perform in the first instance. Distinguishing the president's official actions from his unofficial ones can be difficult. When the president acts pursuant to constitutional or statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the presidential authority to take that action. But the breadth of the president's discretionary responsibility under the Constitution and the laws of the United States in a broad variety of areas, many of them highly sensitive, frequently makes it difficult to determine which of his innumerable functions encompasses a particular action. In some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official even when not obviously connected to the to a particular constitutional or statutory provision. For those reasons, the immunity we have recognized extends to the outer perimeter of the authority. Noting that we have refused to draw functional lines finer than history and reason would support. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on mere allegations of improper purpose, thereby intruding on Article 2 interests that immunity seeks to protect. Indeed, it would seriously cripple the proper and effective administration of public affairs entrusted to the executive branch of the government. If, in exercising the functions of his office, the president were under an apprehension that the motives that control his official conduct may at any time become the subject of inquiry, we thus reject such inquiries in Fitzgerald, and the plaintiff there contended that he was dismissed from the Air Force for retaliatory reasons. The Air Force responded that the reorganization that led to Fitzgerald's dismissal was undertaken to promote efficiency. Because under Fitzgerald's theory, an inquiry into the president's motives could not be avoided. We rejected the theory, observing that inquiries of this kind could be highly intrusive. Bare allegations of malice should not suffice to subject government officials either to the cost of trial or the burdens of a broad-reaching discovery. Nor may courts deem an action unofficial merely because it allegedly violates generally applicable law. For instance, when Fitzgerald contended that his dismissal violated various congressional statutes and thus rendered his discharge outside the outer perimeter of Nixon's duties, we rejected that contention. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. B, with these principles in mind, we turn to the conduct alleged in the indictment. The indictment broadly alleges that Trump and his co-conspirators sought to overturn the legitimate results of the 2020 election. Appendix 183 indictment, it charges that they conspired to obstruct January 6 congressional proceedings at which electoral votes are counted and certified, and the winner of the election is certified as president-elect. As part of this conspiracy, Trump and his co-conspirators allegedly attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slates of electors. According to the indictment, Trump met with the acting attorney general and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending letters from the department to those states regarding such fraud. The indictment further alleges that after acting attorney general resisted Trump's request, Trump repeatedly threatened to replace him. Holy shit. The government does not dispute that the indictment's allegations regarding Justice Department involve Trump's use of official power. Brief for U.S. 46, the allegations in fact plainly implicate Trump's conclusive and preclusive authority. Investigations and prosecutions of crimes is a quintessential executive function. Brief for United States 19, quoting Morris versus Olson, the executive branch has an exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. Nixon, 418 U.S. at 693, see United States versus Texas, 599, U.S. 670, 678 and 679, 2023, under Article 2 of the executive branch possesses authority to decide how to prioritize and how to aggressively to pursue legal actions against the defendant who violates the law. The president may discuss potential investigations and prosecution with his attorney general and other Justice Department officials to carry out his constitutional duty to take care that the laws be faithfully executed. And the Attorney General, as head of the Justice Department, acts as the President's chief law enforcement officer who provides vital assistance to him in performance of his constitutional duties to preserve, protect, and defend the Constitution. Investigative and prosecutorial decision-making is a special province of the executive branch, and the Constitution invests the entirety of the executive power in the President. Article 2, for that reason, Trump's threatened removal of acting Attorney General likewise implicates conclusive and preclusive presidential authority. As we have explained, the President's power to remove executive officers from the United States whom he has appointed may not be regulated by Congress or reviewed by courts. The President's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates. And as the Attorney General, it is their most important duties. Internal quotation. The indictment alleges that the requested investigations were sham or proposed for improper purpose, do not divest the President of exclusive authority over the investigation and prosecutorial functions of the Justice Department and its officials. Indictment 10C, the President cannot be prosecuted for conduct within his exclusive constitutional authority. Trump is therefore absolutely immune from prosecution for the alleged conduct involving his discussions with the Justice Department. The indictment next alleges that Trump and his co-conspirators attempted to enlist Vice President to use his ceremonial role. Anyway,